Thank you for joining us on this episode of Legal Angle with Emmanuel Olawale. I have a very important guest with me today. Her name is Carly Edelstein. Carly works with the Public Defender's Office and she handles appeals, criminal appeals, post conviction appeals, and cases that have been decided by the trial court that need redress. She has been an attorney who does this kind of cases for how many years now?
4.5 years.
For 4.5 years. And she has argued before almost every district appeal court in Ohio, even up to the Supreme Court of Ohio. And today we'll be talking about, some of Carly's passion, which is appealing post-conviction cases. And she's going to be, educating us about the process, what it entails, and tell us about her work. Welcome to the show, Carly.
Thank you so much for having me. I'm excited to be here.
I'm excited to have you. And I want you to tell the guest more about you, although I've been trying to introduce you, but you will do a better job of introducing yourself.
Well, thank you. I think I always start by introducing myself as having been a teacher before I became a lawyer. I was teaching out in Los Angeles. I was teaching in a community where most of the kids qualified for free or reduced lunch. It was a community of almost entirely people of color, a lot of folks for whom English was a second language. I loved teaching. I loved being in the classroom. I loved my students and they were growing. But unfortunately, the education system is something that often fails communities like the one I was teaching in. And I ultimately decided I wanted to be able to create broader change for my students. And I thought maybe the law would allow me to do that. So I went to law school to become a lawyer, to leverage all the power that comes from the law and lawyers to create change. And so I've been doing that ever since. I clerked at the Sixth Circuit Court of Appeals for a judge on the Sixth Circuit and was helping him do all of the work at the appellate level. I worked at the U.S. Department of Education's Office for Civil Rights, looking at issues related to racial discrimination in schools, sex discrimination in schools, disability discrimination in schools. I briefly worked at Equitas Health and was running a name and gender change clinic statewide to support the transgender and gender nonconforming community and doing some other sorts of civil type work for folks who were patients and clients of Equitas Health. And then I ended up here. And I think the sort of the thread throughout all of my career has been, access to justice and specifically focusing on racial justice work.
Oh, thank you. It seems you've dedicated your career to fighting for those who are marginalized and those who have not been able to speak for themselves, the powerless. Yes. What inspired you to go into teaching?
Well, my grandmother was a teacher and my grandfather was a teacher. So they certainly set an example for me. I've always liked kids. I've always liked working with kids. I ran after school programs in high school and college. And so it sort of made sense for me to do this kind of work. I wanted to give back in the community. But ultimately, like I said, seeing how the education system was just one of the challenges that the kids I was teaching faced. They went home to have to take care of their siblings because their parents were working 5 jobs just to put food on the table, things like that. Healthcare challenge, access to healthcare, access to all sorts of things that I often take for granted. And so, really, I felt like I needed to take a deeper approach to creating change, even though teachers are doing an immense amount of work to support kids and create change in those lives every day.
Thank you. And while you were in Los Angeles, you just mentioned you were working as a teacher. You were a 6th grade teacher teaching history and English.
Yeah.
And then you decided to go to law school. Before you decided to go to law school, what was it like for you being a teacher? And how long were you a teacher for?
So I was actually a teacher for only 2 years. And while I was teaching, I saw the ACLU of Southern California bring a lawsuit challenging some things that were taking place in the school district. And I saw the kind of passion and the kind of impact that just the filing of a lawsuit can bring. And so I was witnessing as I was teaching just down the street from the schools that were the subject of this lawsuit. I was witnessing the power of the law to transform that community. And so I was doing the work. I was getting my master's degree at the time, but ultimately I was watching this play out, and it really influenced my desire to become a lawyer. And I actually ended up, while I was in law school, working for that same attorney who had filed that lawsuit at the ACLU, because I was just so inspired by the work that he had been doing.
So the power of the law inspired you to go into law so that you can use that power to give power to the powerless.
Yeah.
Yeah. And you did mention that you found that the school system was broken at the time. What do you mean by the broken educational system? What is broken within the system?
Yeah, I mean, I think oftentimes folks, and I'm not an expert, I'm not a policy expert on these sorts of things. I thought about going into policy, but eventually made it to law. We know that schools in lower income communities are not receiving the same level of funding and across the country. I can't necessarily speak to Ohio because I haven't worked in Ohio policy or politics, but that's one of the things that I witnessed. I saw my own students not necessarily accessing the right services to support their disabilities, accessing the right services to support their language status. So like the fact that they were English language learners, there weren't necessarily the tools in place to support those students. I saw that, oftentimes you see newer teachers in some of the lower income schools, and you see that once they are more experienced in their careers, they go work in some of the more suburban communities in Los Angeles. And so the kids that I was teaching weren't always getting the best possible education, the kind of education that I had received when I was growing up.
Thank you. Did you envision yourself being a lawyer that will fight for these kids when you went to law school, and you actually took the time to learn the law, went to law school, passed the bar, did internship under the same attorney that uses power to inspire you? Have you been able to do that what you envisioned to do with the career?
I think I have, in a way. Certainly, we can never anticipate the kind of path our career is going to take. That first job that I had after my clerkship on the Sixth Circuit with the U.S. Department of Education, I felt like I was really sort of fighting in the trenches in a way. Although I was resolving disputes. I was looking at whether folks' rights, kids' rights, had been violated in schools, and trying to figure out ways to remedy those rights violations, excuse me. But ultimately what I found was that I wanted to be able to attack issues sort of from the ground up and make more systemic change. And the kinds of tools that the federal government had at the U.S. Department of Education to create that kind of change, there weren't really sufficient tools to do that. And so while the ACLU can go file a big lawsuit and create systemic change in that way, the Department of Education, it's more incremental, individual case-based change. But what I realized too was that it's not necessarily that I wanted to just go into education law. What I wanted to do was, what I was really interested in, even in education, was racial justice, equal opportunities for kids, no matter what they look like, no matter what their background is, where they're from. And so that's why I think that racial justice thread through my career is so important. And certainly in public defense, we encounter disproportionate treatment in race, along the lines of race, all the time. And so I think it sort of is this natural thread, even though I was practicing in a completely different area of law as compared to now as a criminal public defender.
Yes. Yeah. And now you work, for public defender is a public servant, because you're
Yes.
taking on those cases of people who can't afford private attorneys, and public defenders take a lot of, how do I put it? You don't even get that much appreciation for the kind of work and the effort you put in, and it takes a special kind of attorneys to even go into the public defender's office to decide to work there. So what inspires you to become a public defender?
It was sort of happenstance in a way. It was, I I think criminal law was one of my worst grades in law school. It was never something that I aspired to do, even though I was interested in understanding the inequality that is baked into the system. But again, I never sort of envisioned doing this work. It sort of happened by happenstance, and I think it's the best thing that could have happened for me. And what inspires me every day is my clients. I am very fortunate in my office that I have the time. And, we hear around the country, we hear these news stories about trial public defenders who don't have the time to put into the work, right? That they're so buried in cases that they can't visit with their clients as often as they would like. And they don't have the time to take every case to trial. We know that about the system. But I actually do, as an appellate public defender, have the time to give to every single one of my clients and every single one of my cases. And so I get to know my clients. I get to know their stories. And they inspire me. They have been fighting to try to tell their story to a court. They have now been convicted when they come to me. And then I get the second chance to share their story and to try to highlight, if there were, to try to highlight some of the errors that occurred at their trial, or constitutional violations that occurred at their trial. So they inspire me. I work really hard because my clients deserve the same quality of representation that someone who can pay a top-notch lawyer deserves.
Thank you. Can you tell us about the screening process of your office to decide which case to take?
So I can't really speak to that because I don't do the screening. There is no formal screening. We actually, I think typically, and this is just, I think, get appointed to cases by the courts. That is generally how cases come to us at the appellate level. Then if for example, if I feel very strongly about a case that I've had and I lost at the appellate level, I can then choose to bring that case up to the Ohio Supreme Court, file a jurisdictional memorandum, and ask the Supreme Court of Ohio to take my case. But generally, we are not looking for good cases or bad cases in the same way that maybe a nonprofit organization might or a private attorney might. We get the cases generally that we are assigned by the courts of appeals throughout the state.
Thank you. So you don't even get to pick your clients?
No.
So the system picks the clients for you?
Yep.
Okay. And can you tell us the appeal process?
Sure. So I'll speak from the perspective of a criminal appeal because I don't really know any of the civil stuff. Yes. So my clients, like I said, for the most part, I do appeals, and I'd love to chat with you about post-conviction as well, which is a separate process. But my clients they're generally convicted of a crime, and I represent folks ranging from folks who have been convicted of misdemeanors in the municipal court all the way up to cases dealing with aggravated murder or drug crimes or sex offenses that are, could have life tails attached to their sentences. I do not do death penalty work. We have a separate section in our office that does that. So my clients have a conviction. They're sentenced by the court. And generally, either their attorney will file a notice of appeal, or they themselves will file a notice of appeal, or they will contact our office to file a notice of appeal. That has to be filed within 30 days of the conviction, of the sentencing entry being put on the docket and that becoming final. There are ways to do it if you miss that deadline. In fact, we have done that before for folks. I have done that before for folks. But once you file that notice of appeal, it's an automatic right. If it's a direct appeal from your conviction, you have an automatic right to get your case heard at the Court of Appeals under Ohio law. And so that starts the clock. My clients, when we file, we ask for a transcript at the state's expense. So the court will order a court reporter to create a transcript that creates the record of the case below. You have a period of 40 days to get that done. If you need an extension, those are fairly liberally granted. Ultimately, though, my job, once I get that transcript, is to read the whole transcript and identify things that happen that don't look right to me. Certainly, I don't know everything about the law as I'm reading the transcript, so I flag things to look at later. I look at the exhibits that were admitted into the record. I look at anything else that is part of the trial court record. And then I talk to my client. I say, look, this is what I see. What else do you think went wrong during your trial? I don't expect them to bring me issues because I'm the one who's well-versed in the law. I'm the one who spent 3 years in law school and has since been trained even after taking the bar exam in criminal law. But certainly my clients were there. They observed what they believe may have been errors, violations of their rights. So we talk, I go do research, I figure out whether there are viable claims to raise to challenge what happened below. I write a brief, I file that brief, the prosecutor then files a brief in response, and then I get one more chance to file a reply brief. Once that whole briefing process is done, then we have oral argument. I appear along with the attorney for the state, the prosecutor, in front of a 3-judge panel. I speak. They ask me lots of questions. I try to answer those questions as well as I can. So does the state. And then sometime later, we get a decision from the court. That's kind of a very rough description of what our cases look like in the Court of Appeals.
Thank you. You mentioned that during the process, you file a brief, the other party will also file a brief. What happens in a situation where you file a brief and they fail to respond to the brief?
So that's very rarely happened. If it's just a matter of missing a deadline, usually there's some leeway, and maybe the court will allow them a little bit of space and time to do that. So I'm not sure that I can speak to an example of that happening in one of my cases. Yeah, I think the state and our office were very diligent in trying to get those things done on time because I'm representing people, they're representing the state of Ohio on the other end.
Okay, so is there anything like default judgment in the appellate process?
No, not from my understanding. And so I have argued cases where the prosecutor chooses not to show up to oral argument, but they still have filed a brief, they've still presented their case, and there will be a full decision from the court.
Okay, and after the court makes a decision, what is the next process? Let's assume that. Okay.
Go ahead.
Let's assume that it didn't go in your favor. What is the process?
So the court writes an opinion. Sometimes they're lengthy, sometimes they're not. Often depends on how hefty the legal arguments were that I raised. I have to spend the time really examining that decision because there are a couple different options to move forward from there. Sometimes it was a weak case. We might have disagreements about how it came out, but there isn't really an avenue to move forward with. Sometimes we disagree with the decision of the Court of Appeals. We can ask for that court to reconsider their decision. We don't often do that, but that is a possibility. I've never myself done that. We can ask for the court to hear it en banc, which means the entire Court of Appeals, not just the 3-judge panel, but everybody on that district court can hear the case. I have also not done that in my cases. I think, have done it in the past. I just have not myself. And then another option is to file a notice of appeal and jurisdictional memorandum with the Supreme Court of Ohio. And so that, I mentioned before that a direct appeal, you have an automatic right to that appeal. The Court of Appeals can't say, no, we're not taking your case if it's a direct appeal from your conviction. The Supreme Court of Ohio, on the other hand, these are discretionary. So they choose which cases to take because they're looking at cases from all over the state. They get a lot of cases filed and they don't have the ability to review every single case that comes before them. And the Ohio statute doesn't require them to take every case that comes before them. And so what we do is we file this jurisdictional memorandum that says, hey, Supreme Court of Ohio, this is a really important issue that not only impacts my client, but could really impact lots of folks around the state. We really think you should take this case. And so that we file with them. The state has an opportunity, the prosecutor has an opportunity to respond. Sometimes they do, sometimes they don't. And then the Supreme Court makes the call. They say, we're going to take it or we're not. And so that is sort of that's the state level avenue for your appeals. There are other things you might be able to do after that at the federal level, but that's sort of the end of the state level.
Thank you. If let's say the case goes before the Supreme Court and the defendant, we're talking about criminal conviction appeals now, and the defendant loses before the Supreme Court, what other remedies do they have? Can they go to the federal court?
Yes. In certain circumstances, they can. You can certainly ask. You can ask for sort of reconsideration of the Supreme Court's decision. That generally doesn't happen because it is a very well thought out, usually fairly lengthy decisions from the Supreme Court of Ohio. But yes, if you have claims in your case that are federal claims, they're constant U.S. Constitution claims in your criminal appeals, you can file what's called federal habeas, or a petition for habeas corpus in the federal U.S. District Court. So that's the trial court. It gets really complicated, but it's sort of shifting over to the federal process. And you're telling the federal district court that the state court messed up on the U.S. constitutional issues. That's basically what that process is like. I've only done that once in one of my cases. I'm actively litigating a case like that right now, where it was a U.S. constitutional, what I think is a U.S. constitutional violation. And so I've raised it in the U.S. District Court for the Southern District of Ohio. But that is extremely rare. And success in that realm, in that place, in that space is extremely rare. It's a very difficult ladder to climb.
Yeah. Does the state have the same right to file an appeal if they lose at the trial court?
There are limited opportunities for the state to file. So, for example, if let's say a case is dismissed because of double jeopardy, and we can talk about what double jeopardy means if you like, but let's say a case is dismissed early on because of double jeopardy, the state can appeal that issue. There are certain kinds of things that the state can appeal. If there's an acquittal, if my client gets, it wouldn't be my client because they wouldn't have come to me on appeal, but if a criminal defendant, if a person who is appearing as a criminal defendant gets acquitted of all of the charges, generally the state's not going to be able to appeal that.
Okay. Can you tell us what double jeopardy means?
Sure. And I sort of smile because the first case that I argued in front of the Ohio Supreme Court dealt with double jeopardy. And so I have these sort of flashbacks to that very stressful period. But double jeopardy basically says that it's in the United States Constitution, and it says that you can't be tried twice for the same offense, and you certainly can't serve a sentence twice for the same offense, and that's part of it. So if you get acquitted of a charge, the state can't then bring it again. That's sort of a very rough explanation. It can get complicated and nuanced if you kind of delve down into it. And my case was a little bit more nuanced than that, but yeah.
Okay. Do you want to tell us a little bit about that double jeopardy case without mentioning the client's name? Just
sure. I mean, it's also public record, but it's a very kind of complicated set of facts. But my client had, there was an incident that led to the death of his child, and he was charged with child endangering and involuntary manslaughter, and the state had investigated it, and he pleaded guilty to child endangering. The state under a plea agreement, an agreement with the state to resolve the case. So he pleaded to child endangering, and the state agreed as part of that agreement to dismiss his involuntary manslaughter charge. He served time under that, about 6 years, I think, in prison. I can't recall exactly, some period of time. About that. And once he got out, he was living his life on the outside for a period of time. And then he came in to the police station and said, it actually was an intentional murder. He made a statement that was very confusing. There were potentially issues related to his mental health that were part of the record. And so then he gets charged with aggravated murder. And so there was a question about whether this was a double jeopardy violation. And ultimately it was not, but there were also issues related to his plea agreement and contract law and all sorts of things that once you get up to the Ohio Supreme Court, things get very complicated and interesting. And it's kind of like this, when you're in law school, you get these hypotheticals, these crazy hypotheticals. And once you're practicing, you start to see some of those crazy hypotheticals, and it's a lot of fun. You can see, I get very energized when I get to talk about the law. And so
it looks like a law school question.
Yeah. Oh yes, definitely. And a lot of my cases are like that. And it keeps me on my toes. I never see the same case twice. That's for sure.
Mm, interesting. And how do you manage the expectations of your clients, especially those who are already incarcerated?
That's really a really important question. I have to manage those expectations constantly while also trying to inspire confidence, right? There's a balance between telling them that it's really hard to prevail on appeal, which it is, because of standards of review, deference that is given, that are levels of deference that are given by courts of appeals to certain decisions that are made at the trial level, but also to have hope and to sort of to support. It is very difficult to live in the incarcerated in the institutions, and so they need to keep going and have some hope that their case might be successful. So there's this really important balance between managing expectations because it's so difficult to prevail, but also giving them the space to have hope that they might prevail. So I'm always very forthcoming with my clients. I have lots and lots of conversations. The pandemic may have made that a little bit more difficult over the past 2 years, but lots of video conferences during the pandemic, and lots of phone calls, lots of conversations with family members too, so that everyone feels apprised of what is going on in the case. Because oftentimes my clients will come to me and say, I didn't really get to talk to my trial attorney as much as I wanted to. I didn't feel like I got the chance to tell them my story. I didn't really feel as well represented as I should have been. And I want them to feel confident that they are getting the quality of representation that they deserve. And often that comes with just being transparent about everything that is happening at the appellate level. So that's why I like to talk to folks as much as I can, answer their questions to the greatest extent I can, and also be available to their family members too.
Transparency and honesty.
Yeah, sometimes the answer is there's nothing in. Oh, I'm sorry. Sometimes the answer is that there is nothing in the case, and I have to be as forthcoming about that as I can be. And it's because my responsibility in the end is to make sure that the system is upholding folks' rights and is coming to the proper conclusion, and doing that in a way that doesn't violate the principles that support the system and my clients' rights. So if there is nothing there, I am very forthcoming. I want to engage in a conversation about that. But where there is, I also want them to understand the law that supports the arguments that I plan to raise.
Thank you. You did mention standard of review. Can you elaborate on that?
Sure. And there are lots of different standards of review depending on what we're looking at. So if I am raising an issue about the facts, either if it's a jury trial, so there's a difference between a jury trial and a bench trial. A jury trial obviously is tried by a jury of our peers. The bench trial is actually, you waive the right to a jury and you have the judge decide your case. And that might be a good decision in certain circumstances. But let's assume that it's the jury. And we are talking about, let's say I'm raising an argument to say there's no way that anybody would have been convinced by the evidence that the state presented that my client is guilty of X, Y, or Z. And so that's something that's it's called manifest weight argument. I wasn't at trial. The prosecutor wasn't at trial. The Court of Appeals judges weren't at trial. The people who were at trial and who could observe all of the testimony as it came out from the witnesses were the jurors, right? The jurors were present at trial to hear the tone of voice of the witnesses, to hear the tone of voice of the defendant if he took or she took the stand in their defense, who were able to observe whether the witnesses were looking around the room and evading, trying to answer certain questions. Those are the kinds of things that can't be reproduced by a written transcript, right? And we don't have a video recording of all of witness testimony. Sometimes it is recorded by an audio recorder, but we don't have a video that we get to watch on appeal. And so what the system does, what the appeals process does, is it gives a level of deference to the decisions, that the credibility determinations that are made by jurors when they say, you know what, that person was kind of shifty when they were testifying. I don't know that they're worth trusting. But that person, on the other hand, was really clear and demonstrated a level of confidence that sort of inspired me to find them credible. So that's built into standards of review on appeal. So when when we're looking at the facts, we really have to, we have to poke a lot of holes in the facts on appeal to really call into question the determinations that were made by the jury. But then there are also standards of review for legal questions. And often, if it's just a legal question, it's something called de novo. And the Court of Appeals is going to look at it with a fresh set of eyes. It's de novo, or newness, kind of. And so that would be a sort of example of a standard of review for a strictly legal question.
Okay. Thank you. Yes. Yeah. Post-conviction appeals often take years. Can you tell us the reason for these long delays?
Yeah, so let me, and I want to be clear about some language. So there's the direct appeal of the conviction that I've been describing. So someone's convicted, files their notice of appeal, and then goes through this process. And yes, that can generally, I don't know that, at least at the direct appeal stage, at this intermediate Court of Appeals stage, that takes probably about a year. It could take less depending on where you are in the state. And then if you go up to the Ohio Supreme Court, it can take obviously longer. That takes about a year. There's also this parallel process that can happen at the same time that is called post-conviction relief. And I want to be clear about those differences because they are very different. Our office does both. I have done both. Post-conviction relief, it's a different deadline, right? Earlier I said you have 30 days to file a notice of appeal. Post-conviction, the deadline is 365 days after the day the transcript is filed in your direct appeal. Very confusing. It's statutory. It's under the Ohio Revised Code. But as long as you file a timely appeal of your case, it's 365 days after that transcript is done, basically, give or take. So you got a lot of time to develop this post-conviction petition. And the reason for that is that post-conviction, while the direct appeal is based on what happened at trial, what was part of the record at trial, so the transcripts of what was actually said at trial, or pretrial hearings, or your sentencing hearing, the exhibits that were actually admitted into the evidence and considered by the jury and the judge. That's your direct appeal. You're calling attention to things that happened. Your post-conviction petition, on the other hand, you are calling attention to things that did not yet happen, that are not part of the record, and that you are trying to argue errors, or that your rights were violated, your constitutional rights were violated by the failure to do certain things, or maybe it was the state failed to turn certain things over in discovery. And so you didn't know that, that wasn't part of the record, so you couldn't challenge that on direct appeal. Maybe your attorney didn't look into certain things that you told your attorney to look into. For example, let's say I had a client who was convicted of murder in, name a county, I don't know, XYZ County of Ohio. And they told their attorney, but wait a second, I was in Florida with my friend, right? And the attorney never investigated that claim. That's an alibi witness potentially. Maybe there are other people who they could call to corroborate that. But without having ever investigated it, without having ever presented it at trial, you can't argue about it on your direct appeal because there's no record of it. There's no evidence of it. So that's where you would file a post-conviction petition. That's why you have 365 days, because you might have to find new evidence. So in a post-conviction petition, you raise constitutional claims and you attach evidence from outside the record. So I have filed and successfully litigated a post-conviction petition on behalf of a client who I also represented on direct appeal. There was evidence that was turned over by the state in discovery that the attorney never presented to the court, and that I felt was exculpatory, that proved my client's innocence. Because it wasn't part of the record, I wasn't able to raise it on direct appeal. So what I did instead was I argued that his attorney was ineffective. He received ineffective assistance of counsel. And I tried to prove that claim by adding the evidence that was not part of the record before. So that can also take a long time, 365 days to file. And then it could go on and on. There are lots of different ways that can play out moving forward.
Thank you. In a situation where the trial counsel is allegedly provided ineffective assistance, mm-hmm. and you filed a motion or an appeal based on ineffective assistance of counsel, can that counsel file a reply brief to defend themselves?
So this is not a civil case, and I'm sure you've had folks who do civil work on your podcast before. That would be more of a civil sort of, defending themselves in a civil action kind of argument. I did in that post-conviction proceeding. We got an evidentiary hearing in front of the court to prove the claims that we raised in our petition. The attorney had tried to file something that was actually stricken from the record because it was not a viable filing in a post-conviction setting. So that's just my experience. It's possible that other folks have allowed it to happen, other judges have allowed it to happen, but my experience has been that it was stricken from the record.
Thank you. Is there a timeline or a deadline for discovering new evidence that could exonerate a defendant?
So that in the post-conviction setting, again, it's generally you've got those 365 days. There is an avenue for filing a delayed an untimely post-conviction petition. My experience has been that those are very rarely granted. And so really you need to do your due diligence during that year. Now, if someone comes out of the woodwork who was unwilling to make a statement before that, let's say I had an investigator try to talk to someone and they just were unwilling to say something, and down the road they are then willing to say something. That is a possible way to file a delayed post-conviction filing. But generally you really do need to be diligent about your investigation during that year, that 365-day period.
Thank you. In a situation where a defendant has been convicted and sentenced and then decided to file a direct appeal, can you also file a motion to stay the incarceration and have them released while appeal is pending?
Yes. So folks are probably very familiar with bail, like the bond at the trial level, that, because our system presumes folks innocent, then oftentimes folks are trying to not be held while their trials are ongoing. And there are all sorts of things out in the policy world trying to reform that, which I am not familiar with. I don't work in that area, and I'm sure you've had folks talk about that here before. But the same sort of process can happen at the appellate level and at the Supreme Court level too. So I have filed for what we call appellate bond. I can't think of the revised code section right now, but basically you make the same kinds of arguments that one, my client is not a flight risk. Two, that my client does not present a risk to the community. Oftentimes I will do this for if I've never filed one of these before for a client who was convicted of murder or something at that sort of higher level felony, category at the end of the spectrum. But for clients that haven't had particularly violent cases or violent criminal histories, I try to get them out so that they can be with their families. So I have had success in some of my cases and in certain districts around the state filing those. I've also been able to file at the Supreme Court of Ohio level to request bond while they are deciding whether or not to take a case. So it stays the decision, it stays that sort of period of incarceration, and the person can be home with their family while a case is being decided either at the appellate level or at the Supreme Court level. And it is a tool that I have used. We use it sparingly, but I have used it with success in certain circumstances.
Thank you. Does that cover only those who are yet to be incarcerated, or does it cover those who are already in prison?
I have had a client who was already, by the time we got to be appointed in his case, he was already incarcerated in the Department of Rehabilitation and Correction. And we filed, and then we were able to get him released from DRC custody. When we lost his case, he did have to go back into DRC custody, but he entered prison, left prison, and then went back to prison after his appeal was over.
Thank you. Have you ever had a situation where, while the appeal is pending, the prosecutor realizes that maybe Brady violation, they have evidence that they didn't turn over, and they decide to cooperate to have the sentencing or the conviction vacated?
I have not had that happen. And it's possible, just not to suggest that the state is hiding the ball. Certainly, I just haven't had that happen. It's possible that kind of discovery situation has not occurred in my cases. What I will say is there have been times where, not in a direct appeal sort of setting. I also do some other kinds of work outside of appeals and post conviction, very very limited, but it is sort of post conviction in a way. I have been working on some cases where folks who are not citizens of the United States have pleaded in a way that puts their status in this country in jeopardy. And so I have filed, and I'm thinking of one client in particular, but I have filed a motion to withdraw a guilty plea on the basis of that. There's a case out of the United States Supreme Court, Padilla versus Kentucky, that says that folks who are not citizens are entitled to counsel, adequate counsel, telling them the potential consequences of pleading guilty to a crime. So these immigration consequences of pleading guilty to a crime. And where my client, where her immigration status was put in, her status in this country was put in jeopardy by a plea that she entered years ago, I filed this motion and am now working with a prosecutor to try to come to a good resolution for the client. And so there are opportunities to engage in that kind of work to support people when the law allows you to.
Thank you. In a situation where a defendant is successful in appeal, but then they've been incarcerated for a while before the successful appeal, are they entitled to compensation from the state?
That is completely beyond the scope of the work we do and beyond the scope of my knowledge of Ohio civil law.
Okay. How do you define success in a system that is very slow to reverse convictions?
That's a really great question. And in a system too where I lose a lot, where my clients lose a lot. And like I referred to these standards of review before, my clients already been found guilty by the time they come to me. So success is a really interesting question. And I talk to lots of folks about that, interns and new attorneys, and how do you sustain yourself in a job where success has to be redefined. I will say this, I can't even think of a client who has not been grateful for my representation. And I'm not saying that in a way to make myself feel better, but I think they themselves have also redefined what it means to be successful. And that's also part of the managing expectations that goes into my relationships with my clients. Oftentimes success is telling my client's story in a way that humanizes them in a system that sometimes takes some of that humanity away. Sometimes success is just getting a decision from the court that acknowledges what my clients have gone through, but also says that the law does not allow for the relief that you're requesting. And sometimes it really is a win. And so I think being open to all of that sort of spectrum of success, and working with my clients to understand that they have to be flexible, unfortunately, about that too. But really and truly, I actually have I'm looking behind my screen right now because on the monitors, behind the monitor that I'm on, I've got a bunch of Post-it notes that remind me what it takes to kind of get through this work, to keep going and not burn out. And I say, remember, you are always fighting an uphill battle for your clients. Remember, sometimes you are the first person who has listened to your client's story, really listened to your client's story. And I think that is so critical. I pride myself on doing that. I pride myself on the kinds of relationships that I establish with my clients. And I also am so proud to work in an office where I think everybody can say that about their work too, and their relationships with their clients. I work alongside some really incredible attorneys who care very, very deeply about their clients and the work that we are doing on behalf of our clients. And I'm grateful to be able to say that.
Thank you. It's one thing to balance or measure the expectations of clients. It's another for an attorney, especially one who cares and someone who has empathy, to recalibrate or manage their own expectations. Being in a job or working with clients, fighting cases that most oftentimes you are not winning, how do you, as a person, with emotion, as an attorney who cares? How do you manage that?
I think it's, again, going back to redefining what that means, what success means, what my career is doing. One, I am representing an individual. I am telling their story. I'm making sure that a court understands the import of their decisions on the lives of real people. But I'm also, what's really great too, is that by representing folks statewide, I'm actually given the opportunity to observe trends in the law. I'm able to identify sometimes, and we do this, we look out for issues that are really affecting lots of people, ways in which the law is being interpreted that are harmful and potentially not necessarily the correct interpretations. And so by observing things statewide, by being able to do that, I am also often fighting for systemic change. And that's when we bring cases up to the Ohio Supreme Court. And so where a loss in an individual case will strike a blow both for me and certainly for my client who has to live through the consequences of that loss, that we always see them as opportunities to try to push the law forward in ways that are meaningful for our clients. Certainly ways that the law allows. We have to work within the bounds of the law, but the law is not always black and white, and we see our jobs as being able to push the law forward and advocate for different interpretations of the law.
Yeah, thank you. And currently, you are seeking to become a judge on the Court of Appeals. So you want to move from being behind the lectern to being on the bench.
That's right.
What inspires you to seek to switch the roles?
Yeah, and I think it comes back to what I see as my responsibility as an attorney every day, which is to help the court understand the import of its decisions on people. And I want to see that reflected on the bench as well. I hope, and actually the current administration, the Biden administration, has been talking a lot about putting public defenders and civil rights attorneys on benches around the country. And I think I agree with that premise, because I think we need a diversity of perspectives on the bench. We have a diversity when you look at there are a lot of former prosecutors on the bench. There are a lot of folks from law firms on the bench, whether it was defense side or plaintiff side law firms. We don't often see public defenders on the bench who have been representing the most marginalized of people who can't afford an attorney. And I want to bring that perspective to the court. I want to be able to share that with my colleagues on the bench. This is what this decision will mean in the life of someone who is currently incarcerated, is afraid that their story is not adequately being shared, and is going to have to experience the consequences of this decision. And that is what I'm excited about. I love my job. I think you can tell that I really love being a public defender. I love working with my clients, but I also feel a very weighty responsibility to bring that experience and that perspective to the bench. And I'm hopeful that this November I'll be able to have shared that with enough people to get to the 10th District Court of Appeals.
And which of you said the 10th District Court of Appeals, can you tell us which areas that the court covers?
Yeah, so I'll give you a little bit of a broad strokes, the system in Ohio, and I probably should have started with that. But we have our common pleas courts. There are municipal courts that are city level and sometimes county level around the state, and they deal with mostly like the misdemeanor cases. And I'm just talking about the criminal side right now. There's also obviously the civil side, which is a whole other beast. And then there's their common. So the common pleas courts are a county, each county, or each of the 88 counties around the state. There's another court called the Court of Claims. It's going to get way too complicated for me to talk about that. So, but my clients mostly are appearing in the common pleas courts. They get convicted, and then they come up to the Court of Appeals. There are 12 district courts of appeals throughout the state. There are 3 that are single county. One is Cuyahoga, that's the 8th district. One is Franklin County, that's the 10th district, and one is Hamilton County, and that's the 1st district. And then the rest of the districts are larger just because of geography and population. They encompass more counties. And then all of those 12 districts funnel up into the one Supreme Court of Ohio. So the court that I am running for is the 10th District Court of Appeals, and that is the Franklin County, the Court of Appeals for Franklin County. So generally, the cases that come to the 10th District come from the municipal court and the municipal courts and the common pleas court. Then there are also other cases that come from various state agencies because Columbus is the state capital. And so it's a large swath of stuff that is very exciting. I love the law. I am excited by the possibility of always being kept on my toes. My job already does that. But so that is what the 10th District Court of Appeals sees and does.
Thank you. And what kind of appellate judge do you envision yourself?
A thoughtful one, one who has empathy, one who exercises the same sort of characteristics, has the same sort of characteristics that I have now as a public defender. I understand that my responsibility as a public defender is to, I said before, to ensure that the rule of law is upheld, to ensure that my clients' rights are not violated. Oftentimes a success at my level, and I should have probably said this earlier, a success at the appeals level sometimes leads to, the end of the case, but oftentimes it actually leads to going back down and doing it over again, because what our system requires is confidence. We need to know that we can be confident that our system is doing it right. And my job is to identify places where it's gone wrong, if it has, and to represent folks for whom things have gone wrong below. And I think that is the exact same responsibility of a court of appeals, to ensure that we can have confidence in our system. And so in order to do that, I want to be thoughtful. I want to really engage in the law. I want to dig deep into each of those cases. Like I said before, my office gives me the opportunity to do that with each of mine. And the Court of Appeals, I believe it's the same way. Each judge should really be engaging with the law and the cases to make sure that they're coming to the appropriate decision. And I want to exercise empathy as well, that the empathy that I've learned from engaging with my clients as a public defender.
Thank you. Before you became a lawyer and advocating for people who have been convicted or incarcerated, I think you went to law school in Mississippi?
I actually went to law school out in California. I volunteered during law school in Mississippi and worked as an intern down in Mississippi as well.
Okay. Well, you are an intern, you are among those who pushed to have an historically Black elementary school reopen. Can you tell us a little bit more about this?
Sure. So I was really fortunate. The law school I went to had a really strong pro bono program. So they, almost every student volunteered, provided free legal assistance to folks. As a student, we were not lawyers at the time. And one of the opportunities I had was an alternative break trip during my winter break in my first year of law school. I got to go down to Mississippi. This was back in, it was shortly after, I can't remember exactly how many, I think it was about a year after the oil spill. So obviously already the South had experienced Katrina back in the earlier 2000s that really decimated a lot of the communities down there. And the populations, many of these communities, the populations never came back to sort of the vibrancy and the size that they were before. And then the oil spill also sort of deeply affected communities right along the Gulf Coast. So we went down there initially, like the point of the trip was to go volunteer to help with this organization, the Mississippi Center for Justice, with their efforts to support fishermen, shrimpers, people in the tourism industry, people who were impacted by the oil spill financially. We were supposed to be helping them file claims to get assistance because of the losses they were experiencing. But there was this one project as well that was in the area of education, and everybody knew that I had been a former teacher before law school. And so I got into this project while most of my peers were working on the important oil spill relief. And what was happening was this school that had been during during Jim Crow in the Deep South, it had been a segregated school for the African American community. It was an elementary school, and it after desegregation, this school was still an incredible force in the community, and it actually was one of the blue ribbon schools in the state of Mississippi, one of very few blue ribbon elementary schools in this area. And so it was really just contributing immensely to the community. But because of population concerns, the school district had to close some schools down, and this was one of the schools that got closed. And members of the Black community, including the local NAACP chapter down there, were concerned that this was a decision that sort of smelled of discrimination. And so we were looking into it, we were investigating, we were trying to come up with legal claims to reopen the school, whether it was, equal protection claims under the Constitution, or whether it was contract law claims because of some weird stuff in history. And so I really enjoyed doing that for that 1 week, but it wasn't enough for me. So I actually came back for my first summer in law school. I worked there for 10 weeks. I lived down in Biloxi, Mississippi, worked for the Mississippi Center for Justice, and was coming up with arguments so that we could challenge those decisions. And actually now, not just because of my own work, but the school has reopened, and I'm not sure if it's now K-5. It was at least recently K-2, and it was serving a very diverse population of students, not just students from the African American community, but it was serving these students well, and it was doing a wonderful job to sort of lift up that history, that this long history that it had in the community.
Oh, that is awesome. And you have 2 young daughters.
I do.
Yes. Who I believe, will be inspired by your run for office. What message do you have for these little girls and for other young girls out there?
I think it's just, I have always been delivered the same message that my brother was given when we were both young. My parents made sure that I knew that I could accomplish anything my brother could. I have certainly experienced some sexist behavior as an attorney just during my career. Actually, not necessarily as a public defender, but in prior jobs, and not by my employers, but by just experiences I've had out in the legal community. And so I want them to know that if this is what they want to do, look at what a woman can accomplish in this field. But I really also want them to know that they can accomplish anything they want, and I will support them. And hopefully the community will be right along with them in supporting a girl, a woman, in doing all of the things that men can do. I hope that they can see me in a black robe and say, wow, like mommy is doing really cool things and really trying to make a difference in the world. And hopefully I will be able to inspire them to do the same.
Thank you. When people go to the poll in November or throughout your campaign, what do you want them to remember you for?
I want them to remember me for compassion, fairness, and a desire to fight for and find justice in a system that is meant to do those things.
Thank you very much. I really appreciate your time, your insight, and your expansive knowledge explaining to us the appellate process and the work you do. Thanks again for coming onto Legal Angle.
Thank you so much for having me. It was a blast.
Thank you. And for those of you watching us or listening to the podcast, thank you again for joining us on this episode. Until next time, stay blessed. And don't forget to follow us on Instagram, Facebook, and subscribe to us on YouTube. And tune in next week for another wonderful episode. Thank you once again. Bye for now.